One of the most important ruling of the Nigeria's financial marketplace was delivered last Friday by Justice Mohammed Idris regarding the unlawful removal of Ndi Okereke as the Director General of the Nigerian Stock Exchange. And opinions have been out there in the media regarding the actions of the SEC last year. The judge says it was hasty, reckless and irrational. Awarded $500 million in favor of Ndi Okereke and a lot of talked about what exactly is a 180-page ruling manuscript contain. Let's try to scratch the surface right now as we dig deeper into understanding the legalese of the legal documents. Ikechukwu Ikeji, an attorney at law, live to us here in the studio. Thank you very much, simply known as IK if you want to use that. That's the expression in Nigeria for being here. Thank you very much for all the time. I'm sure you've read the newspapers and all that about what happens about this. So, reading the letters of Justice Idris really wouldn't have the full copy yet. But from what we grab from the newspapers, give us your thought about it.
Yes, the simple principle there is that no matter how right or good or plausible an action is by a government agency, it has to follow the rule of law. No matter how passionate you are about an action, you have to walk the action within the ambits of the rule of law. That is a simple lesson here, Bosin.
You think the judge was right and correct when he says this is a nation of rule of law and not of rulers?
Yes, I think he is right, and perfectly so, to say that this is a nation of rule of law, a constitutionally operated nation.
If you within the legal team of Ndi Okereke, if you're a member of the team for Ndi Okereke and the judge says that the actions of the SEC were reckless, irrational and hasty, how would you think the judge arrived at that statement?
Well,
what were his considerations?
Let's just start this way. That SEC has appealed that decision, and insofar as they have appealed it, there's a limit. There's a limit to which we can comment on the case, on the substance of the case. However, that having been said,
SEC says it will appeal. It hasn't filed an appeal.
It hasn't filed an appeal. If it hasn't filed an appeal as at now, that information we are not so sure about it. We can conveniently comment on the decision of Justice Mohammed Idris. And if I were on the team of Okereke in UK, yes, I would clap for the decision. I'll just give a resounding applause.
When the judge says a decision was hasty, if you have a client, yes, who's been treated the way Ndi Okereke was treated in August last year,
yes,
how would you read irrational and reckless action?
Irrational simply means that the SEC didn't follow the proper procedure. You see, there's a fundamental principle of law called the rule of fair hearing. It has a twin principle. It stands on two legs. Yes, the principle of order alteram partem, that is, hear the other party, and the principle of nemo judes in causa sua, and that means that you cannot be a judge in your own case. If you are reaching an administrative decision, for example, you must ensure that these two principles are applied in your administrative decision, and that means that you must hear the other party. You must give him an ample opportunity to defend or react, as it were, to those allegations you have leveled against him.
Those ample opportunities were not there. Was that what the judge meant?
Obviously, that's what the judge meant, yes.
So when the judge went ahead to say that those actions taken, those letters written to Ndi Okereke to the Council of the Exchange were null and void and of no effect whatsoever and howsoever, yes, how do we interpret that, the common man?
It's simply put, the common man will just say that it's as if Ndi Okereke was not sacked. Simply put, she wasn't sacked. It is presumed that she's still on her seat. She was still on her seat. However, note that she was to have retired a month after the incident took place. So ordinarily,
proceed on leave.
She was to have proceeded on leave.
Retirement leave, yes.
Retirement leave.
So we're asking the question about the rights of Ndi Okereke right now, yes, on the basis of this Idris ruling.
Yes, her rights do not extend to going back to take the seat of the DG or the nomenclature, whatever nomenclature is given to the position of the head of the stock exchange. Her rights includes taking advantage and benefits of all that would have flowed to her through the process of her having to go through the retirement leave that she was to have gone. In other words, taking her back to starting school as if she is going to retire as she has.
In practical sense,
yes.
Does that mean she can at least go into the stock exchange without any fear of molestation or whatever to say, I need to clear my desk, I need to prepare a handover, or prepare it at home and say, I want to talk to the stockbrokers on the floor, for example, for my pull out and things like that?
Yes, yes. All those rights are clear. But the caveat here is that it's as if she was the DG as at the time she was sent packing. And a month after that, she was to have proceeded on leave. So even if she was still the DG then, she will still not be on the seat now. So the law is that she will not be on the seat now. However, all those things that ought to have been done as a natural consequence of her being the DG as at that period would have to be done. Pulling out, like you said, addressing the stockbrokers as, like you said, clearing her table, like you said, preparing a handover date, a handover note, as you rightly pointed out.
Let us get on to talk about the SEC, because we have a time, as you said, this discussion is continuing. The SEC as a reckless regulator, to use the part of the expressions of Justice Mohammed Idris, SEC has said it will appeal this ruling, yes. And based on two fundamental issues, says the judge refused to take cognizance of certain portions of the ISA and yes. What have you on yes. one side. On the other hand, said that there are certain allegations leveled against Ndi Okereke that the judge did not take cognizance of.
With due respect to SEC, you see, when issues of fair hearing are brought to the fore before a court of law, the court has no business going into the substance of the case, going into the questions whether or not the person who was denied the right of fair hearing committed the offenses or the allegations as were alleged against him or her. Yes, so SEC at this point, with due respect to them, are not properly, in my view, they are not properly advised as to
by their lawyers.
Yes, for them to come out and say that the judge didn't take the principles, the substance of the case into consideration before reaching. Yes, because if you start saying that an armed robber, you saw an armed robber shooting a victim and dispossessing the victim of all his items, then all you need to do is to put the armed robber on the floor, put a tire across his neck, and burn him jungle justice. That is not the rule of law.
Extrajudicial.
You take him to the court and let him explain himself. That is what I'm saying. So it's no matter, irrespective of how plausible, how correct, how idealistic, how passionate the governmental body, the governmental agency feels about a particular action, it has a duty, a constitutional duty, to go through the rule of law.
One of the most very interesting part of this, trying to look at the battle, the legal battle ahead for the SEC, if it decides to go ahead on appeal up to the Supreme Court, is this. The SEC itself said in a press statement, and in the statement read on national and international television by Aruma Ote last year, August, that the allegations against Ndi Okereke were unconfirmed as at that time. Now, Ndi Okereke did not go to court on any base of any allegation. She went just straight for a fundamental human right.
Yes.
So Justice Idris could be given
a pass mark. Let's say it. Yes, a pass mark, without prejudice to the other grounds of appeal that SEC may raise. If they raise the issue that the judge didn't go into the allegations against Onyuke, as it were, then they are on the wrong footing. But if they bring up other grounds, which it's not, I'm not in a position to speak on presently, probably the appeal court will look at it and upturn the decision of the High Court. But no matter the allegation, in spite of how bad the situation is, how corrupt, in quotes, Okereke Onyuke was alleged to have been, she ought to have been given the right of fair hearing. And that is upon the basis, that is the basis upon which the judge made his decision. Based on that, there will have been no need to go beyond that bridge to start inquiring whether or not the action by SEC was right or wrong. Yes, given the fact that SEC has ample authority to take actions, to take effective actions to correct the situation in the market.
So how are you folks in the legal community taking these? I'm sure this is a very important kind of ruling in which a certain individual, a plaintiff, goes to court and gets all counts in her favor against the defendant.
Yes, we are happy about it. We are always very happy when decisions are given that enrich the law. This is one of the decisions that would enrich the law, as it were, because it has added more impetus, more authenticity, more genuineness to the call for the operation of rule of law and the requirement of fair hearing, fair trial, fair hearing, fairness in anything, justice. Justice itself has to do with fairness.
In terms of not just the SEC, any other government organization that rules via a law or a statute vis-a-vis the Constitution and fundamental human rights, you think this is a very important
it's an important decision for governmental agencies to take a cue from. Remember the action of Lamido Sanusi when he came in, CBN governor. He took some very radical, very good steps. However, those good steps had a comma, as I would say, onto them, because it failed to take advantage of the rules of fair hearing. As time went on, you saw that he reversed himself, so to speak, you know, and some of these cases too are still in court today on still the same principles of fair hearing.
We're just getting information now from the Securities and Exchange Commission that a notice of appeal has been filed. What does that mean in legal terms?
What it means is that where a notice of appeal has been filed, the status quo remains, and the principle is that the judgment of the court will be kept pending, because there's a notice that this decision, although the SEC also has a responsibility on their part to file for stay of execution, that is to stay the execution of that particular judgment until the hearing of the appeal. But where they don't do that, there's also a collateral principle that since you have a notice of appeal, that you would have to wait until the appeal, or you are able to show to the court that the appeal is of no substance, then you can execute. You can go and levy execution on the judgment of the court.
So what do you think Ndi Okereke should be doing now? Let's get back to that. What should she be doing in practical terms?
In practical terms, I think she should be preparing her defense at the appeal court. I think she should be preparing to stick, as it were, to those fundamental principles of rule of law, fundamental principles of fair hearing. She should stick to them, because those are very simple elements. By the time she starts going beyond the principles of fair hearing to go into the substance, she may complicate matters and leave herself open to attacks from all angles. Once she sticks to that principle of fair hearing, not being given the opportunity to be heard, she has a very strong ground to succeed. And again, she should be preparing, like you said, her handover notes, and she should also be preparing beyond the 500 million that was awarded to her as damages. She should also be preparing to receive all the perks, as it were, that she would have been entitled to if she had retired and left.
Very interesting. We have about 5 more minutes. Let's grind through this. The SEC, the Securities and Exchange Commission, while the case was before Justice Mohammed Idris in Lagos, tried to prevent that court from hearing, since it lacks jurisdiction. And the SEC went up to the Supreme Court, but was sent back to Lagos to defend that particular issue before Justice Idris. How does that count into the SEC saying we filed notice of appeal, we're going back to the same court of appeal, we're going back to the Supreme Court if possible? Yes.
It only delays the effective takeoff of the judgment. You know, in the event that the Court of Appeal and the Supreme Court upholds the
Federal High Court,
judgment. You see, going to the Supreme Court to query jurisdiction, I'm not particularly in possession of the details of the appeals that they went to the Supreme Court with. But
the courts awarded costs in favor of Ndi Okereke.
Yes, it's a simple principle. Even a new wig, that is a new lawyer today, knows that SEC is a federal government agency, and any action against SEC, or any action that SEC intends to take in the law courts, ought to be taken, can be taken to the Federal High Court under Section 251. The Federal High Court has exclusive jurisdiction. Now, the fact of going to the Investment and Securities Tribunal does not remove that exclusive jurisdiction of the Federal High Court to hear some of these issues, especially where it has to do with breach of fundamental rights, constitutional breaches. If you are talking about market issues, strictly in strict language, issues of the market,
or maybe a stockbroker takes an investor's money. Good.
You may talk about going to the IST, for example, but where you're talking about fundamental rights enforcement.
It's a Federal High Court.
Federal High Court and the State High Court, as it were. Even the Okereke in UK had the right. There are rules of law. There are cases that have decided that you can approach either the State High Court or the Federal High Court to enforce your fundamental rights. So she also could have gone to the State High Court. Yes.
And to still be proper for that case to be tried under a Lagos High Court jurisdiction.
On that for the fundamental rights enforcement. Yes. Very, very positive about that. However, note also that matters affecting SEC as a federal government agency come within the exclusive jurisdiction of the Federal High Court. But if it borders on fundamental rights, the victim, as it were, has a right to go to the State High Court or the Federal High Court as it so wishes.
This is the early days. You think this is an interesting discussion?
Very interesting. Very interesting. It's unfolding. It's unfolding. It will help us. It will help the Nigerian executive and the Nigerian government, as it were, to understand the difference between military government and civilian government. Democracy is a different ball game.
Do you think this will also lead to a further interpretation of the powers of the SEC within the ISA?
Yes, it will lead. Yes, this has
set limits.
This has set limits to, in fact, not only to SEC, not only to SEC, but to all federal government agencies.
The central bank,
NDIC. You don't take action without giving fair hearing, fair opportunity to the other party, to the person against whom you are taking the action, to defend himself or herself, or to say, as it were, what he or she knows about the allegation for which you want to convict him, so to speak, for.
Very interesting. We'll bring you back in the next couple of days.
You're welcome.
When we get the document, we learn it's a very lengthy one.
Yes.
And I'm sure
I'll have the opportunity of going through it myself, and then I can speak very well.
We will be able to look at a few other statements made by the judge. For example, part of what he said was that Ndi Okereke should not be referred to as the removed Director General.
Yes.
That's correct.
Yes, that's very correct. She shouldn't be referred to as the removed or dismissed or sacked, as it were. That would be defamation. For you, now that you are in the media, you use that language, you are liable for defamation, except when that decision has been upheld.
Ndi Okereke could take me up on that.
She could take you up on that. She should, in real terms, she should be the ex-DG, because Equity Regards has done that which ought to be done. She ought to have retired voluntarily a month after her sacking, her purported sacking. So, for now, May 2011, she should have been referred to as ex-DG, not sacked DG.
Very interesting. We need to watch my words.
Yes, please do.
Moving forward, we need to watch how we refer to her. She's a dynamite right now.
Yes.
Oh, sorry, that ruling is a dynamite.
Yes.
You better be careful how you touch it.
Yes.
Before you touch a nerve one.
Yes.
A live one. We'll see you.
Thank you so much.
The other side.
Thank you.
Ikechukwu Ikeji, an attorney at law, will be back here, of course, to regular feature, not just on Business Morning, but other programming here on Channels Television.